Good afternoon, everybody. Good afternoon to all of those joining us from broadly the European area. Good morning to those in the Americas. Good evening to those further to the east. I'm delighted to welcome you to this book launch for Migration and the European Convention on Human Rights, an event that's jointly organized by the European Society of International Law, ESIL, and the Hertie School of Governance. This is a large Zoom meeting, so I would encourage everybody to turn off the microphones, be on mute, and while others are speaking. My name is Christian Tams. I'm Professor of International Law at the University of Glasgow. I'm also a member of the board of the European Society of International Law and the general series editor of ESIL's book series. ESIL is a society for international law in Europe, but with potential global reach. It's open to everybody. It's a learned society that seeks to shape the discourse about international law. And it does this in many ways through conferences and events, but in particular through publishing books, academic books on questions of international law. And together with Oxford University Press, ESIL runs a dedicated book series which publishes high quality scholarship. That's what we think of as our flagship series. And the book we're launching today, Migration and the European Convention on Human Rights, is part of that flagship series. Now, each and every book in that series is special, but Migration and the European Convention on Human Rights is particularly so. This is a wonderful collection of essays, a mix of stories, some sad stories, some stories of hope, often detailed legal analysis, but also a dose of Jacques Prévert. So it's a great book. You'll hear a lot more about this book in the course of this event. Let me focus in this welcoming remark on the joint venture behind it, because this is something that the European Society is very proud of. This is a book that has grown out of collaborations between the European Society and the European Court of Human Rights. It reflects the close relationship between ESIL, an international law society based in Europe, and international courts based in Europe. And the fact that this book has been published and grown out of such a collaboration shows that these links that exist are not just there to be cherished, but are actually very productive. And so it's a real pleasure for me to see the links reflected in the list of editors, two of which, and that's Judge Motoc and Judge Bianku, worked at the court when the book was produced. So Judge Motoc, Judge Bianku, on behalf of ESIL, we're grateful that you made this collaboration happen. And we hope we can build on this, and we look forward to future joint projects. Başak, Professor Çalı, my fellow series editor on the ESIL board series, I know that this has been hard work for you in particular. We're delighted you've initiated this project, and we're delighted even more that you've seen it through. We're proud of this book. I'm saying this to all three editors and to the contributors. And I hope, Başak, that you're at least a little proud, not just of the book, but also of yourself, together with your editors, for having put it together. It's really a wonderful contribution to scholarship. And to all of you, the editors, the authors contributing chapters, many thanks on behalf of ESIL for joining this project. May this book be widely read. I hope it can contribute to making lawyers and decision makers view migration again as a fundamental human rights issue, not just a security concern or a threat. This concludes my introductory remark. And with this, we can begin our substantive discussion of the real topic of today's event, the substance of this book. As you've been told in the chat function, this discussion will be recorded for the benefit of those who cannot join us now. The discussion will primarily be, at least initially, in the form of a panel discussion with statements by experts on key themes of the book and some of the pressing questions that it raises. Our panel will be chaired by Professor Catherine Costello from the Hertie School of Governance, which is partnered with ESIL for this event. Catherine is a professor of fundamental rights, and she is the co-director of the Center for Fundamental Rights at the Hertie School. So panelists, be aware, she comes with real expertise to the topic. Catherine, I'm excited about this collaboration between Hertie School and the ESIL, and I look forward to our panel. And with this, and with thanks to the audience for listening to me, I hand over to you. Many thanks.
Thank you so much, Christian, for those kind words, and a warm welcome on behalf of the Centre for Fundamental Rights at the Hertie School. As Christian mentioned, I'm a Professor of Fundamental Rights and co-director of the Centre with Professor Başak Çalı. So it's a really lovely occasion to come together to celebrate this work, to celebrate Başak and her co-editors and the contributors bringing this work to that's so important and timely. To hear from them. And it's really a critical juncture, I think, in terms of the work of the Court of Human Rights on migration. The pandemic era has made all sorts of new constraints and restrictions on mobility apparent. And I think the human rights challenge in this area is all the more acute. So my role this evening is to chair the contributions and the discussions. Our very distinguished panel have agreed to keep to time and to make short interventions around 5 minutes each. And then hopefully we'll have some time for general discussion. I know several of the other contributors to the volume are also here. To make that feasible with so many people, I would ask you to use the chat function when we get around to the question and answer portion. So you can either post some very succinct questions directly in the chat and I will put them to the panel, or alternatively, you can simply type, I have a question, and we can ask you to switch on your camera and pose your question directly. In the meantime, I would ask everybody, please keep your microphones muted and your cameras off. Otherwise, the recording of the event won't be feasible. So I just remind all of you, before we start the substantive proceedings, please switch off your camera and mute your mic. So my final task is to introduce our speakers. Obviously, we have the three editors of the book here, all also contributors, so that's wonderful. So of course, our first speaker is going to be Professor Başak Çalı, my co-director at the Centre for Fundamental Rights and Professor of International Law at the Hertie School. She'll be followed by Judge Ledi Bianku, who is, as you know, a former judge of the European Court of Human Rights and also a professor at the University of Strasbourg, and also a former member of the Venice Commission for Democracy Through Law. Our third distinguished speaker is going to be Judge Iulia Motoc, a judge of the European Court of Human Rights and professor at the University of Bucharest. Then fourthly, we have Professor Yuval Shani, who is professor of international law at the Hebrew University, and until very recently, a member of the UN Human Rights Committee. And last but absolutely not least, we have Vera Freit. Vera is a doctoral researcher at the Centre for Fundamental Rights at the Hertie School, writing on issues about human rights at borders, and also a former lawyer engaged in strategic litigation in her role at the European Centre for Constitutional and Human Rights, and litigated cases before the European Court of Human Rights. So with that, I'll hand over to you, Başak, directly. And then, as I said, all of our speakers have agreed to keep to 5-minute interventions. Thank you.
Thank you. Thank you very much, Christian. Thank you very much, Catherine. I'm delighted that the European Society of International Law and the Centre for Fundamental Rights at Hertie are launching this book. As you see, the book has a very ambitious title. It's called Migration and the European Convention on Human Rights. It doesn't have a subtitle, and it doesn't tell you which area of migration or which area of migrant rights that it focuses. So when we brought all our wonderful contributors together, we were actually very conscious about making this choice of actually calling the book Migration and the European Convention on Human Rights. One of the reasons for this was that we were very interested in trying to get an overview of different stages of migration and different types of rights that are engaged at different stages of migration, and how the European Court of Human Rights was actually dealing with these. So when you hopefully get the book in your hand one day, or if you look at it online, you will see that the book sort of tries to trace the chronology of migrants through Europe. So the opening chapters start with the right to flee. So people trying to reach Europe or to flee their own jurisdictions. So this is sort of the very beginning of it. And then it continues with the right to seek asylum and how the court engages with that. And then starts looking at conditions of immediate rights, for example, rights in detention of, in particular, children and vulnerable groups, socioeconomic rights of irregular migrants who are still in Europe, but for shorter periods of time. And then the book sort of extends the time horizon and it starts looking at rights of long-term migrants. And here we have some wonderful contributions on both cultural and religious rights of migrants, but also about removals of long-term migrants from Europe. So what we as editors hope is that the book is going to give you an overview of a very wide range of rights that are engaged in this temporal, wide-ranging stages of migration. So I think this is one of the contributors that the contributions that the book is doing. We have an amazing scholarship on various areas of migration and the European Court of Human Rights. So there has been a lot of studies on the asylum aspect, conditions of detention aspect, and various other aspects. So I think what I thought that was really needed in our field was to see this full stages of migration, which means that we could see this comparatively. So if you want, you can read this book as a comparative analysis or of how the court is dealing with very different rights and issues that are engaged in the context of migration. So in that spirit, the book has different parts. So it starts with the beginning, so the immediate entry questions, and then it ends with the rights of long-term migrants. So I hope that this a little bit whets your appetite about how maybe to look at the book and how the book engages with all these stages. So this was one of the, I think one of the most important things about how we approached the book was about this temporality, this very broad temporal scope that we had. Now, the sort of the second area where I think the book really contributes to our existing discussions and literature on migration and the European Court of Human Rights is that it starts with this very significant and a very important problem. And this problem is twofold. On the one hand, the European Court of Human Rights is steadily receiving thousands of applications concerning all stages of migration. So here what I mean again is the right to enter, right to remain, right to stay, right to proper treatment, right not to be deported, right not to be removed, cultural rights and religious rights. So the court is an institution whose door is knocked constantly on these issues for quite some time. But on the other hand, the word migration is not even in the convention. There are no migrant rights in the European Convention on Human Rights. And as we know from the drafting history of the European Convention, this was not at the minds of any of the drafters that the convention will speak to these problems. So this is a very important point of departure for us, what we call the conventional silence. Or the silence of the convention in relation to migration. And of course, on the other hand, thousands of litigation concerning migrant rights before the European Court of Human Rights. So we asked each of our authors, what do you make of this? So, what do you make of the silence? What does the court make of the silence about migration in the convention? How does it address the problem? How does it interpret these issues? What kind of internal or external resources that the court draws on? And of course, a very significant question that we asked all our authors is, you think the court is doing well on these issues? And I hope that when you read the book, you will see that our authors are not in agreement with one another about how well the court is doing. I'm just, again, hopefully trying to give you a bit of a more curiosity here. Some of our authors are a lot more critical of the court, and others are saying, well, not so bad, given that migration was not in the convention. And you will see that there's a lot of in-between conversation or conversation also between our authors in this. So perhaps two very small final notes from me about the approach of the book, what it covers and how it covers it. Of course, there's an incredible amount of case law analysis in our book, expertly carried out by all of our amazing contributors. So what we did at the end of the book was also to offer a very extensive case law list to all of our readers that actually, again, looks at the case law, the European Convention, from this notion of the stages of migration. So at the end of it, you can also see this sort of the wealth of the case law where the court has really struggled in, sometimes very successfully, as some of our authors will say, sometimes very unsuccessfully. I think I'm one of those authors in the second bag of the discussion. So you will also be able to see all the data, if you will, all the material and all the case law and some incredible case law analysis that the court presents. I'm very delighted to have been one of the editors of the book. I have learned a huge amount through the whole editorial process. I've also had a lot of incredible help. It takes, you know, a village, I think, to edit a book. And I'd like to, in particular, thank Stuart Cunningham and Christina Hattas, who have also done some incredible work in bringing the book to completion as well. So I hope you read the book, and I hope that you know, you find its contribution to broadening the scope of how we approach migration and the European Convention of Human Rights, a well thought out contribution to this field. Thank you.
Right. Thanks so much, Başak. Over to you, Judge Bianku.
Thank you, Catherine. First of all, let me thank all the contributors and the editors of this book, the contributors and editors who participated in the conference at the European Court of Human Rights in Strasbourg in 2017, in October 2017. And my thanks to Başak, to Iulia, and also to the Oxford University Press staff who made possible this book, to Hertie School, to ESIL, European Society of International Law as well, who kind of assisted us all along for making possible this publication. I would like to stress a peculiar component in the publication of this book as to the contributions. The conference which preceded the book and the book itself, to my opinion, are the outcome of a very interesting dialogue between the judiciary and the academia. I always believe that this dialogue is crucial and it must be continuous between the judges and the academia, who both have the mission of protecting human rights, rule of law, and democracy. Only their perspectives, their respective perspectives are different. And this makes their interaction between the two extremely important and enriching. And this has been also the case with the Conference on Migration and European Convention of Human Rights and this book, indeed. I'm not saying here that judges should always follow the professors and what the professors say. I'm saying that judges shall sit and decide cases on a well-informed situation, doctrinally speaking, and be put in a position to decide properly their cases. The book and the conference, they've been an excellent example of a frank and open dialogue and allowed both judges participating in the conference and later writing the contributions for the book, and also the academia, in a position where they were, as Başak said, critical, but also able to analyze whether the progress made by the European Convention of Human Rights, by the European Court of Human Rights through its case law, were kind of following the right path, whether the developments, especially during the past 30 years now, because this process started mostly mid-1980s and beginning of 1990s, have brought to an effective protection of asylum seekers and migrants. The area which is the object of the conference and of the book is an extremely delicate area, which is an ever-evolving topic: migration, asylum, not only from the perspective of case law, legislation, regulation by administrative authorities at different member states, but also factually speaking. What happens in the borders of Europe, in the high seas in Europe, we see it every day. They bring new legal questions, some of them extremely difficult. The fact is that for the past 5 years, I can say, the biggest number of the cases dealt by the Grand Chamber of the European Court of Human Rights, if we take a single topic, has been the migration issue. Only this week, we had cases both in Strasbourg and in Luxembourg dealing with migration issues. So this once more makes the dialogue, which reflects the concerns, the developments as well, extremely useful and important. The book, as I said, had the benefit of looking at the developments of the protection of migrants from the European Court of Human Rights from both these perspectives. So the academic perspective and the judicial perspective. On one side at the conference and as contributors on the book, we had several judges which have maintained, to my opinion, a rather open and frank position on the developments in Strasbourg in this area. And the others, on the other hand, we've had some outstanding professors who have been participating very openly and frankly and criticizing the case law of the court and inviting the judges present to reflect upon those developments. And here, I think, will be one of the main kind of contributions of the book that will kind of invite European judges, but not only. And I really hope, I have a special thought of the national judges and asylum administrative authorities in the member states, who might reflect of some of the issues discussed and debated in the book, and hopefully invite them and assist them in better protecting the rights of migrants and asylum seekers, because they are on the front line of this very, very difficult task, especially in some member states. I believe that this process of the dialogue between academia and judiciary was present as well within the editorial team between Başak, Iulia, and myself. Of course, Iulia and myself were at the court at the time, but I also consider Başak as a friend of the court and someone who knows very well the case law and the judicial policies of the court. So we had a very interesting dialogue and cooperation in dealing with different articles. I must also thank all the contributors for their outstanding cooperative spirit in reviewing, discussing all the paragraph by paragraph, their contributions, which I personally think made this dialogue interesting, but also the book very very helpful and interesting to read. So with this, I would conclude, and I really hope that the book will be helpful for students, academia, judiciary, and I repeat, especially judiciary in the member states, the national judges. And I'm confident that the book, especially in the way how it is construed, will inspire continuous dialogues on the way how the European Convention of Human Rights is applied in migration issues. So thank you once again.
Thank you so much, Judge Bianku. And I concur about the openness of the mode of expression in the judges' chapters, including your own. In fact, I taught it today and told my students to read in particular one of your observations at page 100, which I think was a very insightful one about the position or sometimes the silences on the Refugee Convention in the case law. Judge Motoc.
Thank you very much. I also thank Başak and Ledi. I thank Oxford University Press and ESIL and all the contributors for this wonderful book, I will say. First of all, I will talk about the cooperation between the European Society of International Law and the European Court on Human Rights. This is not the first book which was published under this cooperation, it is the second book. But to start with where cooperation started in by the end of 2014, where I joined the European Court on Human Rights, coming for the Human Rights Committee like Yuval and for the University of Bucharest. And in 2013, when I was elected, the president by the time of the European Society of International Law, Laurence Bossan de Chasnur, visited Bucharest, and we had a conference there. So it was the era where European Society of International Law expanded. I have to say that I was myself a member of the board of the European Society of International Law, member of the first board of the European Society of International Law, which was elected in 2004 in Florence. So I feel very attached for this society. So afterwards, when I was elected at the court, I thought that maybe we can do a kind of collaboration between the European Society of International Law and the European Court of Human Rights. And the first conference was held, I think that both Başak and Ledi remembered, that it was held in 2015, and it was the conference regarding the relationship between the International General Law and European Convention on Human Rights. So this book was published afterwards in 2018, which was co-edited by Anne Van Aken and by myself with the ESIL collection. I think is the second book with the ESIL collection. And the conference was such a big success. I think it was the first conference held in a court by a society. And it was such a big success that afterwards in 2016, we organized a second conference. This conference was about the crimes of the convention and the crimes of the past. And the number of participants was huge. And also, I think the number of speakers was really very, very big. But this, unfortunately, this couldn't be published for several reasons. It's only on the web of European Court on Human Rights. So this is the third conference that we have organized in 2017 with Başak. By the time she was the president of, she was the Secretary General of the European Society of International Law, and with my colleague Ledi Bianku. And I think the result is really rewarding. And we see this dialogue between the judges and academics. And we have to say that also the judges in the book, they are also academics. So this is something very interesting to see how, for instance, you can have one hat one day, a second day you have another hat, and which kind of hat you have when you are going to write. Of course, you have a certain kind of reservation as a judge when you are writing, even if you are an academic. But I have to say that the judges in this who are author in this book, they are quite critical to the case law of the court. And maybe I would say that this is some tones in this court are more in this relationship or critical view, but I think it is very good. So I think colleagues took this very positive. The other judges, they were during the conference, and I'm sure that the book will be very well received by the court now. So this dialogue between judges and academics, essential dialogue. I think the society afterwards continues, and I think the court will continue with this dialogue. Unfortunately, we had a conference schedule, but we couldn't have it because of the pandemic. Another dialogue, I think, which is important in this book and give the complexity of this book, is the dialogue between the convention and the court in Strasbourg and the court in Luxembourg. A lot of articles made this reference, and it is a dialogue, and a very productive dialogue in this area between the two courts. And it's covered by the articles, and I would say it's a kind of richness of the articles in this book. And even now, Ledi gave an example of this week. I will give an example of a very important case of the Grand Chamber and of migration that was adopted last year. Of course, is not covered by this book. That is MN versus Belgium. It's a decision of inadmissibility. And at the same time, it's about having visa in the consulate in a foreign country, and our court find that we don't have jurisdiction, and the court in Luxembourg also had a case, XX versus Belgium, with the same content, and the court in Luxembourg had a different approach, but this approach was also related to the fact that it was a question of jurisdiction for them as well, but given the principle of attribution, where they are related with in the framework of the charter. So we see in this book the dialogue between judges and academics about judges of different jurisdictions, about judges of different European jurisdiction, and also I think the richness of the conference and the richness of the book is that we see the connection between several social sciences and law. Some articles, they have rich anthropological background. And we know that migration was really analyzed in all corners by the anthropology. So we have a lot of information, maybe before having been dealt by the international law. And also, to a certain extent, we have some philosophical underpinnings, so philosophical thinking in this book, and which is, at the end of the day, a book about the migrant, the migrant that was imaged by Hannah Arendt, who stay as a main philosopher in this area, but also, the concept that was there with migration for Kant to Walzer, saying the concept of human dignity. I think that all these things are around and give the complexity of this book. And thank you very much. And again, thanks for having this book and organizing this launch at Hertie.
Thank you so much, Judge Motoc. And those comments are very insightful. And for those of us who watch both your court and, of course, the Luxembourg court, I think these commonalities and indeed frictions are always fascinating. I mean, I think perhaps there's some frictions also evident, particularly on detention in light of Ilyas and Ahmad. Our next speaker is Professor Yuval Shani, and so I'll call on Yuval.
Yes, thank you. So I will pursue the same theme of commonalities and frictions, and speak a little bit about the perspective of the ICPR and the Human Rights Committee on some of the issues introduced in the book. But first, I want to start by congratulating the editors and contributors for what is a very interesting and very important book. And it is important because migration is an important topic in and of itself, but it is also an important topic for the doctrine of human rights law and the development of the doctrine. Again, not only because the sheer size of the issue and the phenomenon, but also it brings to the forefront questions about limits of margin of appreciation and about the weight which will be given to sovereignty vis-a-vis individual protections and the scope of jurisdiction, ratione loci, and the how does a state-centered human rights system interact with a regional division of labor arrangements. So these are very fundamental issues that I think the book is very successful in tackling, both from a practical but also a theoretical perspective. And I think I learned a lot from reading chapters in the book about a right to flee as an emerging right and a trend towards normalizing asylum, the tensions that the court is confronting on issues of sovereignty vis-a-vis protection, specific categories discussed in the book, such as long-term migrants, child migrants, and the specific challenges raised by specific rights, such as socioeconomic rights, family rights, non-discrimination, and cultural rights. So well done to all speakers. Now, to all contributors and editors. Now, in terms of the Human Rights Committee and its approach to some of these issues, I will start with commonalities, and I will underscore that a lot of the problems that the European Court is confronting, of course, are also brought before the Human Rights Committee and other regional and global bodies. Since we have far fewer cases, but still an increasing number of cases, we have been very much looking towards Strasbourg and towards the way the European Court has handled these issues, and have been learning, and I'm sure that the committee would continue to follow closely and learn from the European Court. And for me, I think the area which when I served on the committee, I mean, the area which was perhaps where we drew most directly from the European Court in dealing with migration has been the whole Dublin process and the Dublin cases, which the court has really established the baseline. I mean, it issued the MSS case, the Tariqa case, the Hussein case, which laid out a certain framework. And when these cases started coming before the Human Rights Committee, I mean, the parties were really arguing them as if they were European court cases, and we were receiving arguments on the basis of the leading cases of the European Court. And in the end, in our case, Yassin versus Denmark, which was the main case that the committee has issued, and subsequently it has issued other cases, the committee really made an effort to follow the approach of the European Court, both with regard to the tests that would apply in order to intervene, and also with regard to the remedies that would be issued. So there is a strong, it's a difficult issue because it deals with a division of labor arrangement. It also deals with socioeconomic grounds for asylum in most cases. And here I think that the leadership of the court was very important and very influential. Another area where the committee, I think, has been walking the footsteps of the court is with regard to the notion of deference. As many of you know, the Human Rights Committee does not follow the doctrine of margin of appreciation in its case law. But in asylum cases, or in more generally in deportation and extradition cases, it does apply, I would argue, a version of this doctrine by introducing a standard of review, which we call clearly arbitrary or amounting to manifest error or denial of justice when reviewing decisions of local courts, generally on matters of fact and domestic law, but in deportation cases, this standard is very prominent in the case law of the Human Rights Committee. So I think here there has again been an influence in the general outlook of what standard of review should an international human rights body apply vis-a-vis state authorities. And I would even go further and suggest that some specific doctrines developed by the court, such as the von Hanover approach, that you would actually look at carefully as to whether the methodology that had been developed at the local court is analogous to the methodology that is used by the court. I think that the committee has gone also in that direction by, for instance, focusing very much on the idea of individualized assessment as a litmus test for evaluating decisions by domestic courts. Where I think there is some divergence is in some areas where the committee has had an opportunity to deal perhaps with issues that have not been frequently brought before the court, such as access to medical service in irregular migration situation, and perhaps some questions about statelessness. I think that the most interesting two areas where I think there is some divergence have to do with the non-application of margin of appreciation to what one could refer to as integrationist policies, such as, for instance, the head coverage disputes in France and in other countries, where the court has been applying a rather generous margin of appreciation approach to local policies. The Human Rights Committee does not apply the doctrine and did intervene in a number of cases. And of course, this has important relevance for the way in which states, the latitude that states have vis-a-vis migrant and migrant descendants in going forward and basically either assimilating them or providing them with some space for cultural practices, even if they are disliked by the majority. And the second area, and the last, and with this I will finish, has to do with the issue of extraterritorial application of the convention, where we know that this is, of course, a very live topic in Strasbourg. We've had two very interesting cases issued by Strasbourg in recent months. But even before that, I mean, MN versus Belgium, I think, was an important case, which perhaps delineated some of the limits of how far would the court go in affording protection to migrants before they enter the country. I would suggest that here maybe the committee has been more adventurous, so to speak, has been going a bit farther. And I will just note two cases which the committee has decided in the last couple of years. One has to do with a case called Aden versus Denmark. It has to do with a family reunification petition that was submitted to Denmark, but from a consulate outside the country. And there, the committee did not rule out the possibility that even an applicant that is a non-national and is outside the country could claim protection of the right. It ruled on other grounds in the end, but it did not rule out that this would be a possibility. And a more perhaps dramatic case of recent is AS versus Italy, which deals with rescue at sea and does adopt a rather broad understanding of the kind of dependency between states and migrants outside its territory that could bring in the protection by the covenant. I think it remains to be seen whether these divergences, whether they reflect a deep philosophical disagreement about the balance between state sovereignty on the one hand and individual protection on the other hand, or between universal protection of rights as opposed to state-centered protection of rights, or whether they are more technical disagreements about interpretation of specific jurisdictional provisions, etc., which may have very important implications in specific cases, but do not emanate from from a fundamental disagreement about the equilibrium between state sovereignty and individual protection. But I guess the jury is still out on how much do we have commonality and how much do we have friction going forward. Thank you very much, and again, congratulations.
Right. Thank you so much, Professor Shaney, and that was so rich. I always thought there were frictions on detention also, so that might be one of those other areas we could talk about. Our final speaker is Vera Freit. Vera, over to you.
Thank you. Well, first of all, I want to congratulate the editors and authors for this fantastic contribution to the debate on migration and the European Convention on Human Rights. When I started reading, I have to admit that I was interested mainly in the first part of the book, because in my own previous work and current research, I focus mostly on access to human rights at the border. But then I really ended up finding all the other chapters equally interesting and insightful. So, you know, as a PhD researcher stuck in my tiny niche, this was great to sort of re-broaden my perspective. And I warmly recommend adding this book to your reading lists as well. I think that it offers a holistic approach covering the different stages of the migration process from entry to long-term stay, and thereby demonstrates the ubiquity of borders, as exclusion takes place not only at states' territorial borders, but also within Europe. Moreover, throughout the book, the authors advance important critiques and also make numerous suggestions for improvement. Given the time constraints, I will mention only a few of them, but there would really be much more to say. And I would, you know, have liked to go through every single chapter, but what I will try to do now is just to pick some points that speak to cross-cutting themes and, yeah, basically provide some teasers to potential readers. So first, there's the point that the court in migration cases often starts its reasoning by asserting the sovereign prerogative to control the entry and residence of non-citizens, rather than first emphasizing the applicable human rights guarantees, such as, for instance, the prohibition of collective expulsion. Then also we find the proposal for an intersectional approach to the interpretation of rights under the convention, and based on this, the conceptualization of a composite right to flee, which would pierce the current non-entrée regime. Another interesting contribution notes that the court not only plays a role in setting procedural and substantive standards for the protection of migrants, which perhaps quickly comes to mind when we think about the role of the court, but it also plays a discursive role. And I think that this third dimension of the discursive role draws attention to how the court sometimes condemns harmful narratives, but sometimes perhaps also condones them. Further notable suggestions for improvement draw attention to the vulnerability and protection needs of minors, as well as the questions around the removal of persons who have lived in the expelling state's territory for many years. I think that overall, the book really provides a fantastic resource for both practitioners and researchers, and I will certainly draw on it for my PhD, and I'm grateful for this timely contribution. I think that in particular, it provides a framework to scrutinize past, present, and future judgments, because it highlights areas for progressive development to improve the protection of migrants. And it also speaks to and about worrying trends that need a lot of scrutiny. Among some of these trends are double standards with regard to the assessment of evidence, as well as new limitations and exceptions. One particularly worrying judgment in this regard is the case of ND and NT versus Spain on summary expulsions at the Spanish-Moroccan border. So to conclude, I want to highlight that the fundamental rights of migrants and refugees need to be protected, in particular when they are under threat, such as right now. Thank you.
Great. Thank you so much, Vera. That was beautifully succinct and insightful. And listening to you, I was minded too that although there are chapters in the book examining many of the sort of doctrinal and conceptual features of the case law, this fairly recent introduction of the notion of crisis as doing some real jurisprudential work in the case law is something that's also worth, I think, some deeper reflection. We don't have that much time yet left, but we have a lot of people in the audience, including some other contributors to the book. So I see, for example, Violena Moreno-Lax, who wrote a wonderful chapter on intersectionality and the right to flee. And I think also bringing attention there to a very under-examined right under the convention, which is the right to leave, which is in protocol to the convention. And vastly underexplored. So I wonder if anybody does have any questions, they could type them in the chat and put them to any one of our panelists. Unfortunately, I think Professor Shaney had another commitment, so had to leave us. I don't see any in my chat. I mean, if not, I might just, well, I'll give people a moment. I might just put one question to the contributors that we have here. And I wonder, Violetta, if you did want to come in and speak briefly to your chapter. But of course, one of the things about the case law, although it's voluminous, is that of course it follows certain patterns. I mean, once you set up a certain framework of analysis, then that tends to stick. And perhaps this is a question for the judicial members of the panel. And in some of the critical chapters in the book, for example, the chapter by Professor Marie-Bénédicte Dembour, she points out specific cases that the court could resile from, but also suggesting a sort of more fundamental shift. And I just wondered, you know, under what conditions you feel like the court actually makes those kind of fundamental moves? Or, you know, and are there instances where, you know, you appreciate advocates actually inviting you to rethink the fundamental in some cases? I don't know if Judges Bianku or Judge Motoc would like to take me up on that. Maybe it's slightly awkward to pose that question directly, but
shall I try and reply to that?
It would be wonderful, yeah. If I put you in an awkward position, then you can give me a bland answer.
Well, no, now I'm much more free than before because I left the court. But you are perfectly right that the development of the court's case law, especially in relation to asylum and migration issues, they've gone by stages. Some of them were depending quite heavily, decisively, I would say, on the development of other notions and definitions under the convention case law, such as the question of jurisdiction. All it started with Surin, for example. If it wasn't for Surin, I'm not sure whether we would have today any case law on migration and asylum issues. So this is a kind of widening the scope of jurisdiction. And this is why all the debate as far as the latest cases, ND&NT and M versus Belgium, all these cases is very interesting, whether the court is restricting. When you say that, do you need kind of influences, or what are the factors that impact the developments in the court's case law? Let me mention the comparison between the KRS versus UK case, the two Dublin cases, KRS versus UK, which was, if I'm not mistaken now, in December 2008, inadmissibility decision, has to do between a removal from the UK to Greece, and the MSS versus Belgium and Greece case. KRS removal to Greece 2008 was decided inadmissible. A year later, almost identical case was brought to the Grand Chamber, and it brought to the result that you know, that has a kind of, as we heard, a universal impact. What was the shift? What was the change that brought the court within a year to change its mind? And it's very important to assess this as well. Well, there are many. First of all, there is the factual situation in Greece and the entire information that the court had, the judges of the court had from the media, from the academia, and I'm turning back again to on the criticism on the KRS case as well. And you have been writing yourself about this case on your multiple publication about refugee law during the years. It was also, and I'm very keen to mention that, it was also the intervention before the Grand Chamber by the Human Rights Commissioner of the Council of Europe, and also by the UNHCR, who brought before the court firsthand evidence what was the situation in Greece. All these factors brought the court in a specific moment of the development of its case law to maintain a specific position. Now the question is whether criticism from many kind of sources, including from national judges, and MSS itself has been followed by criticism, might lead the court or kind of push it to adopt a more restrictive approach. Criticism from member states as well. So that is not to be excluded either. And we've seen in the recent years, for example, you were mentioning Ilyas and Ahmed, with which personally I don't agree at all. And the judgment of this week in the Hungarian case is an attempt to change, although I see it problematic because you cannot change the case law of the Grand Chamber with the chamber judgment. But you see all these kind of influences and criticism that, of course, have their impact on the development of the case law. So this is why the court cannot decide in isolation. The court has to be surrounded by sources of information, proper analysis, proper criticism, and etc. to be kind of brought in a situation as comfortable as possible to decide in asylum cases and migration cases in general.
Thank you so much. There was such a lot of very insightful information in that response, and thank you for your frankness. I think one thing that came through in all the comments, and the book is a manifestation of, in a way, is the openness of the Strasbourg court to different kinds of interlocutors and argument, both formally as interveners, as you mentioned, UNHCR and other interveners, the Council of Europe's own Human Rights Commissioner, but also that openness and familiarity with scholarly argument. And in a way, the book is part of that process. And I think that's really crucial. I mean, we've promised people that we would wrap up 2 minutes ago. Başak, I don't know if you have any final words or if I will do the formal thank yous. We didn't have much time for questions, and we did have a very interesting question from Emily MacDonald on the right to leave, which does feature in Violetta's chapter. And whether sort of a reignited attention on the right to leave could actually give us a little bit of those tools to rethink the conceptual foundation for migration before the European Court of Human Rights. But everybody tonight has said it, but I'll simply concur in saying that this is a really valuable book. It brings together, just as many edited collections do, a diversity of voices, but I think having judicial contributors is one of its real richness, bringing judges and scholars together. You find in it not only synthesis of case law, but really exciting juxtapositions, I think, of cases from different areas. And that makes it not just a standard doctrinal synthetic work, but I think there's some really interesting work being done at the way case law on different topics is explored and juxtaposed. It's not just about doctrinal synthesis. There's a lot of work on conceptual frameworks, just the starting point of the Strasbourg Court about migration and the weight it gives to sovereignty, but also the evolving role of vulnerability in the case law is assessed by a number of the contributors. And I think, as I said, it deals with a lot of contemporary challenges that are, if anything, becoming even more acute. So we hope that it serves in this general, I think, an ongoing process, which is the co-creation of human rights through these interpretative processes, which are not only processes in which judges are, of course, a key actor, but the interlocutors before courts, both formally and informally, I think are really part of a process, an ongoing process to meet, which is a very acute human rights challenge in Europe today. So thank you so much to everybody who joined us. We've had more than 50 people here this evening. And of course, normally this would be the moment at which we would be inviting you for the fun part of a book launch and serving you some good or perhaps not so good wine or other beverages. And that's what we're missing in this online era. But at the same time, it does mean that those of us who are scattered at great distances from one another are getting to be together very frequently. So that is, I think, the trade-off in this pandemic era. And once again, to congratulate Başak and her co-editors, to thank you all for contributing, to the contributors of the book and all of our panelists this evening for their insightful comments, and to thank you all once again on behalf of the Center for Fundamental Rights at the Hertie School, and ESIL, our co-organizers for this event. And thank you all once again.